participating in this debate. I thank you, all of you that are taking part in it by YouTube and other links. The debate is about ADI 5529 that is going to be judged by the Supreme Court in Brazil next 7th of April. And ABIA is an organization that has been around for more than 30 years, fighting for the right to health care and AIDS. And we also coordinate the GTPI, that is a group that studies intellectual property. And our mission is to defend the access to medicine to the population of Brazil. So we couldn't be silent when this provision is going to make the fact that there is an extension of the validity of patents and the infringement of the rights to healthcare to the Brazilian population. That's why we have this webinar to clarify some points in a public debate. We have two very important guests with us who have been analyzing and studying the area for years about the relevance of this session that is going to happen next week, and how it has to do with international law and how we can place it in Brazil. So on behalf of ABIA, I would like to welcome you all and give the floor to Walter Gaspar Brito, our partner at GPI, and I hope you all have a very fruitful event, and at the end we'll have a Q&A session, and the debate is open to the general public, and we want to deepen the debate because what we have seen is distorted realities, mainly for those who are against the sole paragraph of Article 40 in the Brazilian Civil Code. So we want to clarify all these points so that the public debate is richer. So welcome. Thank you, Felipe. Good afternoon for everybody who is participating. I would like to acknowledge Felipe and everyone in ABIA who is organizing this transmission. I'd like to also say hello to Professor Calixto and Marcela, and I would like to say a few words. First of all, I would like to thank ABIA once again for this opportunity so that we can get involved in this project that is very interesting, that has been around since 2016 when we had the first partnership. At that time, I was wearing a different hat. I was not FGV, I was the Allied Universities for essential medications, but life brought me back to this project, and I was very happy that this happened. But I would like to thank again ABIA for this initiative to bring this debate to the general public. It has been a very enriching experience for us at FGV Rio to participate in this legal scenario and in the Center of Civil Society and the Law, where I work. And this subject was very important then in 2016. And now in the scenario of the pandemic, this is even more crucial to face the difficult situation we are living through. So without further ado, I would like to give the floor to Marcela Vieira, who is going to start this round table. And I invite you all to participate in the Q&A session at the end. I would like to introduce Marcela to you. She is the project coordination for innovation in the area of new drugs. And she had international studies in Geneva. She studied the law and social services and intellectual property. And she has also a master's in collective health from the University of São Paulo. Marcela, you have the floor. Thank you for this introduction. And it's a pleasure to participate in this debate. Good afternoon, good morning, or good night, depending, or good evening, depending on where you are. I'm going to start talking about our speakers and explaining how the event is going to proceed. First, we are going to have Professor Calixto Salomão. Then we'll give the floor to Dr. Anand Grover. And after that, we are going to open to debate in the YouTube channel. So without further ado, I'm going to introduce our first speaker of the day. You have had the chance of reading his bio. I'm not going to read it again because it's so extensive. I would like just to highlight some of the main characteristics of his studies for this debate. Professor Calixto is a lawyer from the University of USP, a doctorate from the University La Sapienza in Italy, 2 postdocs, one in Yale and the other in the Max Institute in Germany, in the area of commercial law and competitive law. He is a tenured professor at the University of São Paulo and also the University in Paris. And he created the group, The Law and Poverty, that involves the academic world, that is more directed or focused in the reality, the social reality of our country. This group, The Law and Poverty, studies the historical evolution of poverty in Brazil. And besides this group, he has developed a series of important studies in the area of intellectual property and medications. And he discussed the unconstitutionality of Article 5529. Professor Calixto, you have the floor. Thank you for participating in our roundtable. Thank you, Marcela. I would like to thank ABIA for this invitation. This is a major event, a very important, through the times we are going through. I have a presentation, a PowerPoint one, but sometimes you are going to see some images of the group, The Law and Poverty, has carried out. We compared 2 things in Brazil in a practical way. The duration of patents in Brazil vis-a-vis other countries. And I'll show you some of the images that we have studied. But to start with, I would like to say that I'm going to divide my presentation in 2 parts. First, the Brazilian situation, then the comparative situation, Brazil and other countries. And at the end, I'm going to conclude talking about the constitutionality and what we believe it's the unconstitutionality of Article 5529. Let's talk about Brazil first, but perhaps you have heard this before, but I think it's good to situate. The Article 44 caput defines the validity deadline of patents in Brazil, that is 20 years beginning with the application of a patent. What is the issue? The sole paragraph has added, and I'm going to try to show you what it did. It's the only thing in the world. The sole paragraph has added something besides the 20-year deadline or validity deadline. There is a 10-year guarantee deadline from the moment that this registration has been granted. So, whereas the 20-year deadline exists, there is another one of 10 years from the moment that there is the granting of the application. What is different in Brazil? Because it generates a possibility for any patent holder. If the patent takes too long to be granted, any reason whatsoever, it can be even because the applicant for the registration didn't do the thing right, he still has 10 years, additional 10 years, I would say. So the first characteristic that is very important to mention is that if there is a 10-year deadline from the moment that the patent is granted, and this is guaranteed in any situation whatsoever, what is the incentive for the patent applicant to produce documents in a speedy way or to demonstrate a novelty characteristic or anything else? So the applicant doesn't need to be speedy. So the composition between Article 40 and Article 40 sole paragraph that modifies our intellectual property law isn't the fact that it takes away any kind of incentive for the patent applicant to act in the process of the granting of the patent. And this observation is very important because Felipe mentioned different manifestations that have a reason invoking the discussions of the law and economy. And I think this is not right, because even if we only think about the incentives given by the mere existence of patents that are there to foster innovation, an extensive deadline as ours in Brazil is a disincentive to patents, mainly to national production. Most of the patents we know in Brazil are foreign ones. So if I protect these patents for a very long period of time, much longer period than other countries in the world, I will block, as these patents encompass different patents linked to the same invention. So they block other ideas that could have been brought up by our different national Brazilian industries. So this is the first adverse economic event on innovation itself, on national innovation. And this comes from the first legal effect, that is to foster or not to foster the acting of the patent applicant towards the INPI or Anvisa or other alter keys. It's very important for the applicant of the patent to bring all the documents, to bring the technical exams. So if he has a 10-year deadline that is guaranteed after the granting of the patent. And there is Article 44, that is another provision that protects this applicant from the moment he applies until the concession. The longer it lasts, the better. So the situation in Brazil is very unique. It fosters both the misconduct or the non-effort, let's say, on the part of the patent applicant so that the process can be speedier, and it also demotivates innovation. And also, there is an enormous social cost to the whole process, because it's obvious that this patent has a bigger extension than normal, because the monopoly is protected by a long period, and the prices may go up and up and up, and it will harm our universal healthcare system. And there are drugs against COVID-19 that are subject to this long period in Brazil. This is the Brazilian situation. Let's compare it with other countries.
There's a formal type of situation which is established by law. Most countries, including Brazil, follow the TRIPS Accord that considers 20 years after you apply for the patent. The problem is because TRIPS doesn't define the maximum time, so countries may vary. Most countries do not vary. They stay in the 20-year time. What is important to know that is mentioned in the discussion, it only changes in very specific situations called PTA and PTI, which are the extension of the patent time and the adjustment, PTA, patent term adjustment. Different countries like the European Union have a specific way of these PTAs. The US and Chile has different types of PTA. In all cases, it would be very long to discuss details in each one of the cases. But we can do that if you are curious about it. But I would say that in both situations, the countries, after the patent is granted, when there was a delay which is justifiable in the phytosanitary registration, like our Anvisa, or when there was a delay, that is, they are going to consider if there was a delay by the public institutions. In Brazil, regardless of who have contributed to this delay, if it took 20 years to get the registration, why there was no technical investigation about it? They receive another 10 years, regardless of those who caused the delay. This is the difference. In these other countries, through this PTA, with the PTA and PTE, you only receive an extension of the deadline after the registration was granted if there was an unjustifiable delay from the part of the agencies, the phytosanitary agencies or the patent agency. Once we understand that, I would like to show you some data. So, can I have my first slide, please? Yes, these slides you will see are part of a study in our group. You know, this is not in the site, in the website. It is signed. There are many professors and students, graduate students of USP University. It has different annexes, and you can see the data. I will show you just some specific images that show very well the position that we have in Brazil. But I'd like to invite you, if you want, to read the article in this website, in this group, Right and Poverty, and all the annexes where they explain where this data come from, how they come to these conclusions, etc. So the first slide shows the effective continuation of patents, pharmaceutical patents in the BRICS. Why BRICS? Because they have kind of similar social problems and similar development levels. Brazil, as you can see in this graph, perhaps we could see the next slide. This is the first one. There's just one asterisk. These are the ones that have used this Article 40 sole paragraph. That is, they have an extension of the deadline because of any reason due to this Article 40. As you can see, it can go up to 24 years and a half. Compare with other countries like India and China. They stay on the 20 bracket. South Africa, a little bit over 20 years, and Russia is closer to Brazil, but anyway, still very far away. And Brazil, again, in those cases where there was not the application of this Article 40 sole paragraph for different reasons, including lack of interest in the case of the patent holder. What would happen in Brazil if we only apply Article 40 capus? 20 years. So this is how different it is. You know, there's a discrepancy of almost 5 years. You can say, well, it's not that enough. It's not too much, 4 years and a half, 5 years. Please refer to the study of the University of Rio de Janeiro to see the impact of those extra 5 years on our health system in terms of cost of equipment. Each patent, each monopoly has a huge cost for us in Brazil. So the effects of this 5-year extra time are huge. Let's see this second graph, image number 2. Yes. Let's compare this to our neighbors, you know, the validity of pharmaceutical patents in Latin America. It's difficult to compare, but in Latin America, we have the same thing. Brazil has the biggest period of time, 24 years and a half. Chile has a kind of a PTA adjust, even though it takes 21 years and something, because you have to justify why there is those extension. And all the other countries stay in the time bracket of 20 years, like it was the case of Brazil, if it was not for that Article 40, a sole paragraph. Chile, as you can see, is because they didn't have a PTA before 2011. And then in some cases, they have attributed this extension of the deadline. That's the third image, comparing only Latin America. Well, now in this image, we will compare with developed countries, countries where pharmaceutical patents are the most registered ones, like Switzerland, UK, US, Italy. Even between those countries, and these countries have all the economic incentive to have long patents since they are the holders of the technology. They are the ones who have applied the patent. Brazil is ahead of all of them, 23 years or more. Switzerland, which is the biggest pharmaceutical industry, has less time than Brazil. Italy also less time. The US with PTE and without PTA, almost 23 years, 24 years. Same goes to Sweden. So Brazil is far ahead of the other countries that are considered to be developed countries. Again, I'm not comparing all the countries. We can't compare all the countries. We have to have some criteria, and we had those criteria. But they identify how generous the Brazilian legislation is compared to other countries, all other countries, developed countries, BRICS, Latin America, vis-a-vis the effective validity of those patents. Now let's go to image number 7. In the same paper, we are only talking about averages. 24 years is average. There are some patents that are quicker. Others, the patent holder is more agile, so Brazil goes close to the 20 years. Let's see this graph, 30 years, 31, all on the pharmaceutical industry, 29 years. So we are coming close to 30 years of validity of a pharmaceutical patent. In this table, we have drugs against COVID. I know it's a complex situation. Not all drugs are effective against COVID, but in some kinds of treatments, there are drugs that are used in the case of COVID. So if we don't have this Article 40, this may apply to the vaccines against COVID. One of them is a patent of one of these vaccines. The second one, if I'm not mistaken, it's the vaccine against BCG. We have this patent in Brazil and not anywhere else in the world because they have recognized this extension. So notice how important this issue is. This is very relevant. Sometimes we have to understand the effect of the law to understand the law itself. And this is what we try to do in this study. And as a last image, I want to show you, this is the biggest 10 validity of Brazilian patents compared to other places. See the difference. The 10 biggest ones, we are over 29 years, and most countries are around 20 years, a little bit more or less. So the difference is huge. Well, I guess my time is up. I guess I want to conclude now my presentation. Well, all these empirical data that I showed you are very relevant. They show us that the discussion of inconstitutionality must include those data. If it is true that Article 170 in our Constitution tries to balance different objectives in the economy, like intellectual property, access to essential goods, and the guarantee of public health, not only this article, there are other fundamental rights related to public health. regardless of drugs, but in general, if our 170 article tries to balance all these things, protection, economic development, protection of the intellectual property, of course, if our protection to patents is too much in terms of time compared to the international average and what is said on the TRIPS, there is no balance in these principles of this Article 170. If our protection is too long, we are helping to create monopolies. So we are not in accordance with Article 173, paragraph 4. So there's no respect to the guarantee of social rights as our Constitution foresees. So all these contexts help us see that it is really unconstitutional, and this unconstitutionality must be recognized. It is important for the Brazilian development. It's important to the incentive of vaccination in Brazil, and it is an important process to have access to essential goods and the protection of our society. I thank you all, Marcela, and especially ABIA, for the invitation to participate in this important event. And it will be my pleasure to hear Dr. Grover, who is a recognized expert in terms of right to health. Thank you, Professor Calixto, for your participation. I will make some general comments. Thank you very much for your effort, your and your team, to try to gather all these empirical data. I know it's very difficult to collect all these data with so many different countries. And I guess this empirical data collection for this debate was very important so that we can understand that the situation in Brazil is really very different from other countries in terms of how long, the patents are valid in Brazil. You also mentioned another device in our intellectual property law. The protection starts to be valid at the time you deposit the patent. This is also an important study led by Mrs. Gabriela Costa Chaves, who is also present in our discussion. So this is very important for many drugs that are bought by our SUS, our social health system, and also the extension of these patents of these drugs. So we must keep in mind the consequences that this law have in our health system. They may seem a little bit abstract, but when we go to real life, it makes a difference. Drugs are much more expensive due to this extension of the monopoly time, the monopoly validity, and many people are not able to access health technologies that are very important. This is one of the jabuticabas in Brazil. It also occurs here in Brazil when we have this extension, like we have in Brazil, that generates all the incentives that we mentioned about. So the patent holder himself makes it last longer, on purpose many times, because he's the one interested in having the benefits of this delay due to the extension of these patents. We've heard the legal aspects, and we want to discuss with other opinions that we see in the Brazilian media, because the judgment is coming closer. On April the 7th, we will have this judged by the Supreme Court. So there are different arguments, different players involved, and now I'll give the floor to Dr. Anand Grover, who will bring the perspective of the right to health, making the bridge between patents and access to drugs, right to health, talking about the case in India and how this all relates to the discussion we are having in Brazil currently. So, can you open your
Thank you,
video?
Marcela. Can you see my
Tito?
slide? Can you see my slide?
No, we can't. But I still have to introduce you. Wait a little.
Eu ainda vou
Can you see my slide
apresentar.
still?
No, I can't. I can't. But I will introduce you when they are looking for your slides. Eu vou fazer a sua introdução enquanto você coloca os seus slides. Então, para quem não conhece, o Dr. Anand Grover, ele é...
Well, for those of you who don't know him, Dr. Grover is from the Supreme Court in India. He's very well known for his work in human rights in India, especially for his work for LGBTQ plus people and people who have HIV/AIDS. He has founded with his wife Joyous Collective, a very important organization of lawyers acting in different human rights themes in India, even in the area of intellectual property and access to medication. We have learned a lot with his experience in the collective. And in August of 2008 and 2014, he was special invitee by the UN in the area of health and also intellectual property and medication. He is the first person who has studied the constitutionality of a provision that they have in the law of patents in India. And he has also introduced some safeguards to avoid harmful impacts of patents in people's health. There is an important case from Novartis and the Indian law, and this group led the study of the safeguard that is in the patent law of India, and currently Dr. Grover is member of the Global Commission of Drugs Policies. I'm going to give the floor to you, Dr. Anand.
Thank you, Marcela. Can you see my slide presentation?
No, we can't see your slides. I'm sharing them from my screen. So
okay.
Let's see. Does that work for you?
I'm not going to repeat what Dr. Calixto actually mentioned. We are discussing today the sole paragraph of Article 40, which you are familiar with. It actually extends the period of patent protection for 10 years for any reason, as Dr. Calixto actually explained to you. It is a unique thing in Brazilian patent law. No other country actually has it. And the justification appears to be that it takes a long time to examine patent applications in Brazil. And because of the delay, the examination may itself take up to 20 years, which nullifies the grant. And therefore, after the grant of the patent, which may be at any time, a 10-year period has to be given. I want to go into the background of patenting and why it is so harmful. In the 80s, American pharmaceutical and entertainment companies wanted to have intellectual property law like they have in the US. They wanted to establish monopolies all over the world. So the US introduced IP laws through negotiations in the GATT-Uruguay round. All the other countries opposed it, and there was a split. The split was on the one side, US pushing for TRIPS, and on the other side, countries like India, Brazil, etc., opposing it. But what did the US do? And this is an important lesson for us. And that's why I think Brazil has fallen prey to the US pressures, even in introducing the 1997 patent law in Brazil. The US used a law called 301 and 301 special, which actually threatened to impose sanctions for countries to export into the US. Because of that, they were able to break up the groups of the developing world. And in 1990s, early 1990s, all countries agreed in the Uruguay round to accept TRIPS. India was the last to agree, but why did it agree? I'm not going into that today. It's important to understand how these things are happening. And as you know, the patent law is to allow patenting for new substances and processes which involves an inventive step and which is capable of industrial application. It applies to both products and processes. But the 20-year protection is the maximum that TRIPS allows. So what Brazil has done is what we call TRIPS Plus. There is no mandate for it. Why it agreed, it's a mystery to me, and I can only say that it is because of pressure from the US. And there's an excellent report from the Chamber of Deputies on patent law reform in Brazil, which is very, very telling. And that actually supports the conclusion I have come to, that it was the pressure of the US which actually led Brazil to change its laws. Patents are supposed to encourage innovation. It is supposed to disclose inventions. It is supposed to have innovation and allow development. But what it does is actually creates monopolies, raises costs, hinders competition, and they discourage technological advancement and therefore development. There's a very serious dispute that patents don't deliver innovation and drugs. We can do without it. But the goal of TRIPS, which is to promote innovation and technological transfer, it has not happened. In Brazil, in fact, the Chamber of Deputies have said that because of the patent law from 1997, there is actual capital outflow, which has gone up from 317.173 million US dollars to $1,478,946 million in 2009. So it's huge. So basically, the patent law is functioning to transfer capital from poor to rich countries. That was never envisaged, but that was the agenda of the US pharmaceuticals. Now, very importantly, when you're talking of 10-year extension, what are we talking about? Is it 10 years of really therapeutic drugs which are beneficial, more beneficial than the existing drugs? No. The patent system itself allows for new forms to be patented. So the US study shows that 76% of the drugs have no therapeutic benefit. Only 24% have. In Canada, on the other hand, only 5 to 6% have therapeutic benefit. So when you're talking about the 10-year extension, what sort of drugs are you actually extending the term of the patent for? 76, 80% have no better therapeutic function. So should we do that? And very importantly, this is the habit of the pharmaceutical companies to do what is called evergreening. First, they come up with the base, then they have an ester, then they have another solvent, then there's another molecule. So they keep on extending the term of patent. And that is the way to make a monopoly. That is the way to make a profit. Now, competition is essential. Competition actually reduces prices. And this is a very important graph, well known, which shows that HIV drugs actually used to cost 12,000 US dollars for 1 year for one patient. And when the Indian generics put forward their proposal, immediately the red line, you will see, goes from over 10,000 to less than $1,000 per year, per person. Did they make a profit? Of course they did. So you can imagine how much profit they are making. And even with $100, they're making a huge profit. So basically, the monopolies are to make super profits. And they are what I call criminal profits. They are cheating the public. Now, very importantly, just see the price. In India, at the time when Novartis case was going on, the price for Novartis was $2,400, whereas generics were giving their drugs at about $200, 8.3% of the price. Another combination was only 1% of the price. So the generic companies actually introduce huge competition and lower the prices considerably. This eats into the profits of the multinational patent holders. Now, a lot of myths are there about how much it costs for the blockbuster drugs. Just tell you very simply, there have been a lot of studies which show that the actual cost is very little. $1 billion is a blockbuster drug for 1 year. The company studies of DMASI actually said it was $231 million. In 1999, 2003, it was $800 million. But most of these drugs are publicly funded. Even Novartis was publicly funded. If you look at a large number of the COVID drugs or vaccines, they are publicly funded. And they are not new chemical entities. Only 25% are new chemical entities. So if you break it down, to put it simply, it is according to the latest study of Light and Water, which shows that it is only $24 million that they have to spend to make a drug which is a blockbuster of $59 million. So they are taking in a huge amount of profit and they are funded publicly. US pharma companies have been funded publicly even for Covaxin, Covishield or AstraZeneca, Pfizer, BioNTech. They have been funded publicly by US governmental or public funded institutes. But they are raking in money through various means, including pre-purchase agreements. So they are thinking of trillions of dollars, not billions of dollars. The COVID situation, especially in Brazil, and I'm very disheartened to see that Brazil is going through a huge crisis when at one time it was delivering drugs for HIV positive people. It is the biggest failure. COVID situation is the biggest failure of the patent system. In my opinion, the patent system has to go because it has not been able to measure up to its own goals of providing people drugs. But coming back to our point, the rationale for having 20 years, they're talking of extension of 10 years, but there was a rationale for having 20 years. Prior to TRIPS coming into effect in 1995, in some countries, 2005, say in India, it had a rationale, and that is actually explained in the very famous WTO dispute settlement decision called Canada Pharmaceuticals. They actually found that most countries would actually have the patent and the approval for the drug because there are two different regimes. One is the approval, which is animal toxicity studies, phase 1, phase 2, phase 3 clinical trials to see that the drug is efficacious and actually safe. That takes about 8 to 12 years, and the patent examination takes similar amount of time. So the patent holder gets a monopoly between 8 and 12 years. It's a real difficult question for me to understand why Brazil is taking so long and why should sole para of Article 40 not be declared unconstitutional. And I'm coming to that point now. Article 198 of the Brazilian Constitution is very clear. There's a right to health, which is a fundamental right. But cost of medicines is the key factor affecting the right to health. According to the Chamber of Deputies report on patent reform, about 51.7% of Brazilians stop taking medicines because they cannot afford them. It should be they cannot afford them. And they pay 5 to 66 times the prices of the medicine which are cheapest in the generic in the world. So patent law actually impacts prices of medicines and access to medicines. If it allows patents and monopoly prices, or it allows competition through generic companies. Therefore, it impacts health. Now, Brazil is a signatory country to the International Covenant on Economic, Social, and Cultural Rights. It is bound to comply with the right to health, which is in Article 12. I'm not reading it out. And basically, it says that everyone, in a non-discriminatory manner, which is an overarching right, is entitled to, as a matter of human right, health facilities, goods, and services. That is all. For example, here, medicines must be available. They must be accessible, that is economically and geographically, and they must be acceptable and also of good quality. And these are immediate, non-derogable obligations. So there is a minimum core obligation, as it were, that is access to health facilities, goods, and services on a non-discriminatory basis, especially for vulnerable groups. This includes the provision of essential medicines. Most of the medicines in COVID are essential. Now, why sole paragraph, according to me, actually in violation of the Brazilian constitutional and international health law? It actually prevents Brazil from realizing the rights of citizens of Brazil. The moment drugs are given an extension of a monopoly, monopolist prices are imposed, which over time become unaffordable to the state and non-accessible to the people in the country. Please remember, as noted by the Chamber of Deputies, 51.7% of Brazilians who take medicines stop taking them because they can't afford them. So the right to health and potentially the right to life is infringed. Therefore, it is unconstitutional on the ground of infringement of the right to health and the right to life. More importantly, and this is what I would like Professor Calixto to help me. Basically, there are two types of drugs, as it were, therapeutics, which are given an extension. There are those which are really new chemical entities, and there are others which are new forms of known substances. According to me, these two different types of drugs cannot be given the same treatment of extension. Because new chemical entities are genuinely new therapeutic benefits, but the new forms don't have any therapeutic benefits. They're only for convenience. So treating them similarly in the same manner when they are different is discriminatory on the classical notions of unconstitutionality, right from the US law to even in India. Also, there's no rational relationship to the object sought to be achieved. If the object is to grant patents for genuine inventions, not frivolous or new forms, but giving them the same treatment, new forms and the genuine inventions, the object is not sought to be achieved, it is nullified. So in my opinion, even if the Supreme Court does not strike down the sole paragraph completely, it has an option to read down the provision and say that it can only apply to new chemical entities. Of course, that's not a victory in the full sense, but that's an advance. Now, one of the reasons, and I think the fight should not be only limited to the case in the court, in the Supreme Court, which is coming up in the next week, but it should be a longer fight to change the law. Because Brazil did not take advantage of flexibilities, unlike India, which it did, but India has a history. In 1970, we changed the patent law. We did not allow for product patent protection. We only allowed for process patent protection. What is the consequence? There was no monopoly of pharmaceutical products. Only processes were allowed to be protected. Indian companies could actually go around and have non-infringing processes. As a result, more competition, prices of medicine in India were the lowest. Indian pharmaceutical companies became net exporters. At the turn of the century, in the new millennium, 90% of the ARVs and generic drugs were being exported by India to the developing countries. Today, it has the largest pool of generics in the world for therapeutics and vaccines. That is why we can produce our vaccines in India today. We don't have to depend. Why did not Brazil do that? That is my question. And we have to think again, should we not change the law fundamentally? So TRIPS allowed for a lot of flexibilities. The only thing that they did not actually do, and there's the Chamber of Deputies report which actually makes suggestions for what sort of law they should do. But we actually introduced even a new provision in the law, which is section 3D. New forms cannot be patented if there are known substances and there is no significant efficacy over the known substance. That was the Novartis case which we won. That is a sort of law which Argentina and Philippines have adopted, which has to be adopted by Brazil. Because tomorrow there'll be a major problem as it is now on the issue of vaccine in Brazil. In Brazil, there are no vaccines being produced. Brazil is dependent on China, on India, on Russia, and other countries. It should not be in that position. In my opinion, there has to be serious thinking even after the case to change the law. In Novartis case, the Supreme Court upheld it, and in my opinion, Brazil needs to do away with sole paragraph either through the court process, which I hope the court will do, but even if it doesn't, it should amend its law to do away with the sole paragraph. It also needs to adopt a provision similar to 3D. And if it doesn't happen, the fast tracking of patent examinations should be allowed for NCEs. And once you have a dual system, the time required will come down. Thank you very much.
Muito obrigada, doutor Anand.
Thank you very much, Dr. Anago. Thank you for your presentation. You did not use all your time, so we have more time for debate, for discussion. So if you want to participate, please write your questions on the YouTube channel. While we are waiting for the questions, I'd like to highlight some of the aspects that Dr. Groove mentioned in his presentation, which was very rich, and I hope we will have it available on our website. Well, you brought a historical perspective on the negotiation on the TRIPS agreement about this the discussion between patents and health. Now, with the pandemic of COVID, it is again on the spotlight, comparing to the Brazilian response to HIV, where we had the possibility of fabricating generic drugs. And today, this is not possible anymore due to our legislation. Our Congress decided to change this, and India has adopted, but not Brazil. That's why India was able to keep the production of generic drugs for more time. And today, India exports these drugs for most countries, allowing people to have access to quality drugs. All this issue of patents generating or not generating innovation, we won't have time to enter into this discussion today, but the relationship between innovation and patents, that's what we hear. If we don't have patents, we won't have innovation. If we remove the patents, we will remove the incentive for companies to generate new drugs. Well, this is not a direct relationship according to the empirical data. Comparing the quality of the drugs that are being produced in this system, we see many drugs, many medication that have very little benefit, but they cost a lot. On the other hand, other health conditions do not have any treatment because there's no incentive generated by the patents to generate innovations for these other diseases. Of course, there's also the issue of the effect of patents on the price of the drugs. Competition, monopolies. Some people do not understand why some drugs have a generic equivalent and others do not. Why the original drugs are more expensive than the generic ones. Anyway, the cost of innovation, how much does it cost to generate innovation and who pays for that? Many times it's not the patent holder because, as you said, there's many public money involved. The issue of the 20-year protection, that was not so before the TRIPS agreement. Many countries didn't grant any patents in the pharmaceutical industry, including Brazil. We have to change when the TRIPS was created in 1994, when there was this discussion, why 20-year period of time? And this was never justified. They want to extend this even beyond these 20 years. We have very little empirical data that prove the need of this extension. Anyway, we can also compare the issue of human rights, the obligation of the countries to follow on with this obligation of human rights vis-à-vis the international trade agreements. Most countries are more concerned in fulfilling the international trade agreements than the human rights agreements. But the human rights agreements are as binding as the trade agreements, so they both should be mandatory. We have always to remind our countries about that. Also, there are other devices like safeguards in the Brazilian law. Many times these safeguards are not even used because they have kind of a compulsory license. This was mentioned before, this is the article that is about this extension on the patent validity, the so-called TRIPS Plus, which grants more rights beyond the TRIPS agreement. And all the safeguards that we have that are very much less used by the governments, and also this necessary change in the patent system. And we will discuss about that. We are also discussing in the World Trade Organization, we want to have a suspension of the rights to patent and other intellectual property rights related to health vis-à-vis the COVID-19 pandemic. And all these discussion about suspending those rights have been facing reluctancy or resistance on the part of the developed countries. That's where most pharmaceutical companies have their headquarters. We also saw a change of the role of the Brazilian government that up to recently was a leader in international discussion through the rights of health. But now the Brazilian government is, not so effective in this discussion. It's important to see that these issues sometimes seem very technical, very legal, and very boring, but they are very relevant for our day-to-day lives to assure the dignity of people's lives, not only in Brazil, but all over the world. So now we will open for the questions that we have received in our chat. I will start with the first question from Mateus Falcão. Hi, Mateus. He talks about I will read his question. The trend is not that these requests will be even higher considering the frequent need of biotechnological drugs, which also makes the requests more complex. So, Professor Calixto, if you can answer this first question, please, then we can also give the floor to Dr. Anand. And he asked you a question about the new formula and new chemical entities, suggesting an alternative for our Supreme Court if they do not declare unconstitutional for Article 40, sole paragraph. Try to kind of filter what types of patents could be subject to this extension or not. Can you please answer both questions, please?
Your presentation was very interesting indeed. First of all, I would like to answer Mateus' question. Undoubtedly, Mateus, the trend, well, why is the trend for these time brackets to be longer? I had another graph that I didn't show you, but this is part of the answers of the INPI to the Supreme Court, and we have data that support that. If you look at the Brazilian backlog in the Institute, it's not different. It's not different from the international patterns. We have a graph by the number of processes by examiner. Brazil is different from Korea and other countries. So there's not a big overload on INPI. What there is at the Brazilian Institute of Industrial Property is the fact that they use this sole paragraph to extend the patents. So I don't bring the documents, I don't bring the examiners. So the more complex patents are, it will be easier to extend those periods, those time brackets. So we are fostering what we should not be fostering. We are going in the opposite direction. And the experience of India, it's important all over the world. Everybody knows that. Everybody knows that the Indian experience is based in activists like Dr. Grover. India was never afraid to say, we are going to take 10 more years, we are going to be more flexible. That is, the country, India, has never been afraid of guaranteeing a plurality of producers, and so, doing so, guaranteeing the access. It seems that Brazil has been afraid. We have to accept, otherwise the pharmaceutical companies won't come to Brazil. And this is not true. They have been here forever. Even when Brazil didn't recognize patents, 97% of international drugs we had in Brazil before the 90s, before the new law, they were sold in all Brazilian drugstores. So we shouldn't be afraid of access to medication or competition. The same thing happens with COVID-19. We need to have access to technologies via agreements or via the law. If we can't do it via the law, our next major task as international NGOs, if it's not an agreement, we have to have a mandatory licensing and go to the courts so that we can have the COVID vaccines. I'm giving a long answer because I would like to make some remarks to Dr. Anand. In terms of medications, if we applied everything we should, very little would be patented. Perhaps we wouldn't even need patents. I advocate a very selective system to recognize patents in very specific areas. Perhaps we wouldn't need them in the pharmaceutical area. The second alternative, if we have this system that is enforced today, would be simply to recognize the unconstitutionality of Article 40, sole paragraph 1. I think we should give the Supreme Court alternatives. They have a unique opportunity now to put together social concern and economic concern, because what fosters patents in Brazil is the fact that we don't want the sole paragraph. My option would be to eliminate the sole paragraph from the Brazilian law, and it should be recognized as unconstitutional. If this doesn't happen, and I'd rather believe that it will happen, there is a lack of isonomy in the two situations that you presented between those who bring a real innovation and those who are only a consequence. I would rather answer saying, I trust that unconstitutionality is going to be recognized by the Supreme Court of Brazil. I'm sorry if I took too long, but it's been such an interesting discussion that I had to say more words. Thank you for your comments, for your remarks, Mr. Calixto. Now we have the responsibility. Our Supreme Court has a major responsibility of changing the law. And let's see what they are going to do. We are waiting for the final word of the Supreme Court. At least they have now this historical responsibility. Before saying something else, I would like to open to the next question. We don't have one at the chat right now. The question of new molecules or new formula that you mentioned. I was part for many years of discussions at the BRICS. Now I have a new hat. We defend a new position that many of the new formulas shouldn't be considered in need for patents. And they are only evergreening because they end up by doing the fact that the patents are protected for 20 and 30 years when they are not new formula, but just evergreens. As we are talking again about evergreening, I would like... Oh, there is a question, I'm sorry, in the chat. It has to do with evergreening. How should evergreening be observed by the courts? In Brazil, we have this situation of evergreening that reinforces the problem of backlogs that ends up by generating the exceptions of monopolies of Article 40, sole paragraph 1. What should be the behavior of the companies that should be taken into consideration in the debate of the backlog? And I add also the observation by Dr. Calixto, the fostering that this generates for the applicants of patents to take longer and longer to apply for patents at INPI. There is a number of accumulated applications that should be analyzed by INPI. We always think about the so-called inefficiency of the INPI, that they wouldn't be able to analyze all the applications during the time frame of 10 years. But we should also take into consideration the practice of the patent holders of using evergreening. They apply for patents that they know they are not going to be approved, but during the time of the application and the analysis of the INPI, to either defer or reject the application, the time span is extended. So we have applications of many patents that have no foundation whatsoever. They know they are going to be rejected, but due to this extension, it goes on and on and on. It's a sort of willful misconduct by the part of the companies. Dr. Anand, could you shed some light in terms of your experience in evergreening in the courts in India?
Thank you, Marcela. First of all, let me just say, Angela has been a great translator. I've had no difficulty in understanding what you're saying in Portuguese. Her translation into English has been wonderful. Thank you, Angela. Secondly, I'll come to the experience in India in a minute. It's not one way, it's a mixed bag. But I think Professor Calixto actually mentioned that there are different ways of looking at it, because everybody agrees that sole paragraph of Article 40 has to go. There's no dispute about it. But if you don't get that, as a lawyer, we always have second line of defense, third line of attack, etc., etc. So we don't go to court only with one single aim. We always try to have a layered attack or layered defense, so that we don't come empty-handed out of court. So in that context, I was mentioning that even in court, we should actually first say that sole paragraph has to go because it is unconstitutional. But if the court doesn't agree with us, then we can have riders. I haven't looked at the petition, so I can't really comment on that. But as a lawyer, I'm only adding my 2 bits now. One is, like Professor Calixto mentioned, if the delay is on account of the applicant, then they cannot ask for 10-year extension. Secondly, there should be riders within the procedures of the patent examiner, that they give time limits to everything. That can be done by rules. In India, we have lots of rules which say that you have to make an application for examination. If you don't, the patent is over. Those sort of things can be added. Then, if that is not acceptable, then you have this division between new forms, which are really evergreening products, and the new chemical entities. In my opinion, in law, you can't treat the 2 different types of drugs in the same manner. That's a classical argument on what is called equal protection for unequals, which is not permissible in constitutional law. But then, if it's arguable that it can be struck down on this basis, then you can ask the court to interpret it and say that it should not be available for new forms. And new forms, as Marcela said, the thinking has always been that new forms should not be patented. So we tried to do that in 2005 in India, and the original draft was that new forms should not be allowed to be patented at all. But then the multinational companies got into the act. They didn't realize that there was a strong activist group in India which was actually deciding the law. So when they came in, the government actually came to a modus vivendi, which was that new forms will only be patented if the new form is significantly more efficacious compared to the known substance. So that was a compromise, which actually is okay. So we accepted that. But I can tell you that even now, the patent controllers are not rigidly enforcing the law. So at times, a number of cases, new forms have been patented when they should not have been. There is a failure in the patent controller's office. We have 4 patent controllers' office, north, south, east, and west. But there's a huge amount of influence by patent controllers and universities from the US who come and train our patent controllers, which is an issue which we are very concerned about. So that also impacts, and this is how the multinational lobbies operate. They actually not only infiltrate the government thinking processes, but even training of bureaucrats, etc. So we have to be very careful about these things. So though you may have a good law, it may not be implemented. So that's been one of the problems with the 3D operation. So evergreening, according to me, should be not patentable. The second line of attack is to have like what we have in India in 3D. And the most important thing is that the patent controllers must comply with the law. We don't have the problem like such a long period of time of examination. In fact, for that, you have to have large number of patent controllers or patent examiners. Numbers have to increase, they have to be trained. That can be done. I don't see why it's not being done. Resources must be put in. Personnel must be put in. There's no reason why this 10-year thing should exist at all. You know, I know it's been a big issue, and I'm glad people have gone to court in Brazil. So let's hope on the 7th of April, they'll strike it down. Thank you.
Muito obrigada, doutor Anand. A gente tem mais uma pergunta aqui. Eu vou pedir para vocês, para os nossos dois palestrantes, quando responderem a essa pergunta.
I will ask you that our speakers, when answer the questions, please make their final remarks. I'd like to remind you that there is a project of changing the patent law in Brazil to make the Brazilian patent law to exclude this measure of Article 40, so paragraph, but also other harmful measures so that Brazil can use more safeguard measures. Unfortunately, this change is stuck in the Brazilian Congress for some years, and it needs the support of the population so that this can proceed. The last question we have is how do you see the attempt to try to use the experience of developed countries as a precedent to justify the patent period of time, and other measures of TRIPS, like TRIPS Plus, in developing countries like Brazil? So what we see is this issue. We must grant the patent to reach the same level of technology and innovation of more developed countries. You know, there's this whole theory that's the only way we can come up to the same development level of other countries. But in reality, for countries like Brazil and China, the reality is different. So we must think about the famous theory that many countries, to reach technological levels, they did not grant patents. When they reach a certain level, then they start to grant patents to try and protect their industry. And they kick the bucket so that other countries could not follow the same path. I guess this is what the question is about. Can our two speakers please answer the question and at the same time make their final remarks, please, to conclude this debate? Thank you. Professor Calixto. Well, Dr. Grover will have the final word. This question has, I would say, has a technical answer and some general answers. First of all, if the experience we have is PTA and PTE, if the question is about this, PTA and PTE, I just want to say that what Brazil did is not PTA or PTE, because what developed countries do through the use of this protection is to see if there is a delay due to the controlling agencies, registration agencies, and then they compensate for this delay. This is not what Brazil does. They just grant another 10 years without asking why there was this delay. So this is the first mistake in comparing Brazil with developed countries. And these resources, PTA and PTE, are not only in developed countries. That's why I said there was a technical aspect. But there are also some general aspects. As Marcela said, if the question is about how the countries developed, I tried to show in my presentation that what Article 40 does is really to discourage development in Brazil. You know, in some other countries, certain vaccines, for instance, are not protected anymore. They still are in Brazil, like BCG vaccine, as I said, due to the extension period. So the general answer is, well, this comparison is not valid, because if we want to encourage or foster innovation, we must assure the national technology. And then Marcela point of view about encouraging innovation in Brazil. All these other countries, when it was necessary to break economic power structures, they did. They broke it. There are some famous cases like the US with the Standard Oil, Germany with the IGF-Waben, and many other monopolies that were dismantled to assure the functioning of the economy. At the beginning of China's development, they did it. It was based not on the right of patents, but on the obligation of sharing technologies. So the general answer to this question is, even in general, according to development theories, these countries did not do that. When it was needed, they broke the patents. They reconfigured the monopolies. So even in those situations, if this is the path to follow, we must act on all the structures, including patents. And a good beginning would be to recognize the unconstitutionality of this article. Having said that, thank you very much. It was a pleasure. Thank you, Felipe, Marcela, everybody at ABIA for this excellent opportunity. And that's it. Thank you very much. Thank you. Dr. Anand, please.
Thank you very much. I don't have much to add except on sole paragraph, I've said in Article 40 that it has to go. But on the development and innovation and technology transfer, data is very, very, very clear. And I think one has to understand and realize that the MNCs in the US, Europe, and Japan have a clear agenda. It is for them to make profits and not for their rivals. So now, in most countries, in developing countries, except say China, even in India, they are the second fiddle to the US multinationals. Okay, except say in software, but in medicines and even the Indian generic companies are not innovative in terms of bringing out new drugs or new vaccines. They can do that in the next 10, 20 years, provided there is a clear-cut understanding by the government that they should actually allow for technology transfer to be protected. But the world over, and it's brought out in the Chamber of Deputies report on, it's called patent reform in Brazil. Brazil patent reform innovation towards national competitiveness, and it's actually brought out by Center for Strategic Studies and Debates in Brazil. I got an English version of that, and it makes it very clear all over the world the technology transfer doesn't happen. There's no investment in pharmaceutical companies in developing countries. They try to hinder them. And there is capital outflow from developing countries to the US, Europe, and Japan. So it's another form of imperialism which is going on. And unless that is broken, there is no hope in the long run. And it is sheer luck that we had Mrs. Gandhi in 1970s who changed the law. And it is continuing. And we have still the momentum of that in terms of the TRIPS waiver. But our government, like your government today, is very close to the US. So in the long run, because we have had a history of patent law, we are able to carry forward. But now it's becoming more and more privatized, health services, etc. So I'm worried about the future in India also. But I think we have to be very clear that if we want to develop, have technology transfer into Brazil, then not only sole paragraph in Article 40 has to go, there has to be significant changes in accordance with this patent law reform of the Center of Strategic Studies initiated in Brazil. It's a very good document. It's exactly what we talk about, Marcela. It's what we should have. So I think there has to be a government in Brazil and also in India which actually looks at that. Just take the example of vaccines. Why is it that the TRIPS waiver is not being agreed to by these countries because the multinational corporations want to make more and more profits. They're not going to give that up. And unless we are very clear about these things, we are not going to achieve much. I think Brazil, in terms of leadership, in the 90s were befuddled into believing that patents are a good thing, like they've done in all developing countries, including Francophone Africa, etc. We were lucky. We were just lucky that we had a leadership from 1970 onwards, which was clear on this thing. And how long that will last, I can't say. But we have to now, and instead of being defensive, we have to be aggressive. But let me be very frank, the civil society movement is a broken movement today internationally. The opposition to patents is dwindling. It's good that there are people like Professor Calixto and few professors in India, but we are a minority today. We don't have the same traction like we had in 2001 when South Africa came. This is a major problem for us. Everybody speaks a different language, so it's very difficult now. Even in India, civil society is divided into different parts. We are able to do things, and Felipe was there in the 2 hours ago when I spoke about a petition on compulsory licensing on TB drugs, but bedaquiline and delaminid. So we have filed a petition in the High Court to get them compulsorily licensed or government authorization. So that's a thing we are trying to use to bring the civil society together. The civil society is broken today, whether it's between Europe, America, India, South Africa. There's not that unity that there was. One would have hoped that the COVID-19 crisis would bring us together. It has not. That's the reality. So we are in a weak position, in a defensive position. We have to turn aggressive. I think Professor Calixto has given us some very good ideas. We should move forward in an aggressive fashion. Thank you.
Muito obrigada, doutor Anand. Mais uma vez, muito obrigada, professor Calixto.
Thank you very much, Dr. Anand, Professor Calixto, ABIA, FGV for organizing this event. It's always an honor to participate. I still hope that we will come together, as you said, to put together a civil society to be more united like it used to be. I think we still have a long way to go to face all these new and old challenges. I would like to give the floor to Felipe to conclude officially our presentation today. Thank you all for participating. Thank you, Marcela, for being an excellent moderator. Thank you, Professor Calixto, Anand, Professor Anand, who were very inspiring, bringing very important information for this debate. On behalf of ABIA and FGV, I'd like to thank you all for participating, for contributing with your questions, and then follow our debate. We have high hopes about this judgment next week. We hope the Supreme Court corrects this historical mistake in our patent law that was analyzed by different points of view here in our discussion. It's also important to say that ABIA and FGV have a partnership. We presented the first amicus curiae at the STF. Today, there are other players participating, but our institutions, ABIA and FGV, presented the first petition. And we believe we are defending public interest because the excesses and abuses on the patent system hinder the response to pandemic, they violate the right to health, and they put pressure on the budget of the health system. This is not just in theory, we saw this in practice, and we can say about people that are affected, people who live with TB, HIV, hepatitis C, diabetes. If we take into account the drugs that are already affected by this sole paragraph, we are talking about 97 million inhabitants in Brazil. Almost half the Brazilian population depends on drugs that have felt the impact of this measure. There's no reason. This is a huge threat to our health system. And as we saw here in the debate, this is a compensation for a loss that didn't occur. So there are lots of distortions. It is an excessive compensation for companies that have not suffered any kind of loss to their monopolies. So it makes no sense at all. And it just is a threat for the future of TB treatment in the future. And it is already suffering the impact of this device. It will be difficult for Brazil to offer the best treatment for TB. So there are different threats. This is a very important case for the Supreme Court in Brazil to judge. And as soon as this inconstitutionality is declared, the better, because it threatens social conquests that were reached in Brazil after many years of struggle. So I'd like again to thank you all very much. I hope this discussion have contributed to the public debate with qualified data without being based on bravado and empty discourses to create panic. What we are seeing is a real possibility of having a more balanced system and be able to protect our health system from a huge threat that is always growing year by year. This is our idea. We hope you have enjoyed this meeting, and we'll keep in touch, and we'll follow on this provision of the Supreme Court next week. Thank you very much.
Yeah.